There's one final handout that was in your set of downloadable pieces. It is a checklist, a clerk or stated clerk checklist for preliminary process. If you would get that in front of you at this time. This is sort of the equivalent of the preliminary process guide for remedial, but it was not more than a couple of days after the new rules went into effect that I got my first call from a stated clerk saying, we just had an allegation received and it'll have to be under the new rules. What's the process look like and can you help me? So I quickly put together a checklist of things that the clerk needed to do, which is what this next slide on the screen is about, which is taking us back. We're in chapter 7, but now we have to go back to chapter 3. So after you determine as a clerk whether we're within the time limits and who can file and so forth, and guide them as clerks do, but they still have a right to make their allegation and you still have an obligation to follow through on it. But then down at number 5, we go back to chapter 3, because at the beginning of a disciplinary process, particularly if sexual abuse is alleged, we have to have that review committee ready immediately. So item 5 on the checklist says, notify the moderator of PJC of the need to appoint a special review committee immediately in accordance with D30102. If clerk of session, that is accomplished by notifying the presbytery stated clerk as described in that provision. And that's because the end of that provision says, what's now on your screen, a session shall refer any petition for review to the presbytery stated clerk, who shall follow this process for the creation of a special committee. So the way those review pieces work is, and this is new. They were only created, and they were created by members of the current members of the PJC in the past. Now we're allowing the use of former PJC members, and you appoint the committee at the beginning of the process, and they conduct all such reviews that are named in the rules, of which there are a few. A decision not to move forward with charges, an accused asking for a review of the process at any time, and the review to determine administrative leave if sexual abuse is alleged. So that is a case that's going to be a new one for presbyteries in particular, to need to appoint that review committee at the beginning of a sessions investigation process, so that it's ready to go should it be needed. And as I think we mentioned earlier, this is a place where there's a new rule which says that sessions and councils above the sessions may, and councils above the session shall provide a rule for the appointment of investigating committees. And that transfer of membership is not allowed once that process is started. Then there are sections on the membership of investigating committees. This is stuff that's done by the session or the presbytery. It doesn't involve a PJC per se. So those are going on by the presbytery, but there are rules for who can be on it and how their expenses are handled. And there are also 3 additional defined roles at the beginning of the investigation process: the roles of a counsel, the roles of advocate, and the roles of mediator. We tried to spell out various kinds of assisting roles and spell out later duties and responsibilities of people in those various roles along the way, more than they had been in rules of discipline. So now, allegations of sexual abuse, when they occur, first there's a definition of what it is. It's an offense involving sexual conduct in relation to any person under the age of 18 or anyone without the capacity to consent, or any person when the conduct includes force, threat, coercion, intimidation, or misuse of ordered ministry or position. Sexual abuse is contrary to Scripture and Constitution of the PCUSA and is therefore always an offense for the purpose of discipline. And if that is alleged, then that review committee determines whether or not to require administrative leave. And so that process happens. And there are a couple of special notes about it, that it doesn't depend on the employment status of a minister in particular. That's because we're talking about leave from any pastoral duties. A minister who doesn't happen to be in a pastorate may still be asked to do pastoral duties. And so if they're going to be required to not perform those while this investigation occurs, then you have to have this review to make that determination. So are they allowed to do anything? Are they allowed to perform baptisms and weddings in other churches or not? All of that has to be reviewed and put into the administrative leave clearly. There's a section on the effects of administrative leave, and which is what I was just talking about. They shall not perform any pastoral, administrative, educational, supervisory duties, and shall not officiate at any functions such as administration of sacraments, etc. So that's why it needs to be done regardless of whether they're actively employed. So it's not what we think of as administrative leave of, say, a presbytery employee or something. If leave is not required, there is a special note that an IC can present additional evidence to that review committee at any time. If they said, no, we're not going to require it, and then as the investigating committee does its work, it learns some more things, it can go back and say, okay, now will you require administrative leave? So that can happen. And then there's a new section that actually overturns an existing authoritative interpretation, D70905. Says nothing in this section shall preclude a presbytery from establishing its own rules for administrative leave or other restrictions on a minister's service. So the new rules say presbyteries may do that. There had been an authoritative interpretation that said, essentially, since it says it for a sexual abuse, that means you can't do it for anything else, which is a perfectly good Robert's Rules answer. And so to answer that in Robert's Rules, if you want it to be allowed in other circumstances, you have to say so. And so that's what's said there. Something down below. I heard recently one overture in the works to try to put paid back in there. Okay, well, we'll deal with that when the time comes. It does not say whether it's paid or not as currently written. I think I'm correct in that. It doesn't say that it's without pay, but it doesn't say that it's with pay. Bill, you agree?
I was actually replying to somebody else who was trying to ask you, why was administrative leave changed from paid leave? And I was replying to him that I'd heard of an overture to try to put it back in.
Okay. All right. Now, my understanding, I think this is correct, is that it doesn't say it cannot be paid with pay. It just doesn't say that it definitely is. So that would leave it to presbytery's discretion, I suppose. Okay, and then 710 is what I just mentioned about rights and responsibilities of everyone in the process. These were included to some extent in the old rules, but they're much more developed, we'll say, in church discipline. Rights of the accuser, rights of those alleged to have been harmed, rights of the accused, and responsibilities of all participants. So those should certainly be brought to everyone's attention when you are involved in a disciplinary process. The investigation itself now has a new way of starting. The old rules just said when it meets, it does this list of things, two of which, the first one and one that was down about fourth or fifth, I think, would be ones that cause the committee to stop and not move forward any further. So we decided that those should be preliminary to the investigation, not the investigation itself. Decisions should be made on those on the front end, one of which is, does it actually allege an offense? And the second one, if it alleges an offense, is it an offense that's already been adjudicated, something that's old that they're filing again and it's already been dealt with? Either of those result in stopping the process, pending, of course, the possibility that they could ask to have it reviewed. Yeah, so they were A and D in rules of discipline. So they're now done on the front end. And there are rules that say maybe on the last slide, that first meeting of the investigating committee must occur within 60 days. That is new. Rules of discipline did not have that. And rules of discipline said that there you have 1 year to file charges from the date that the investigating committee is appointed. Now we are saying you have 1 year from when the investigating committee has its first meeting and makes those determinations. Again, there are a number of reviews that can occur. So D712 says at any time during the course of the investigation, at the request of the person against whom the allegation has been made, the review team is brought together and does its review. Then the investigating committee, when it's done all the work that's listed in 712, conducts their review. That's 1103 is everything they do, A through G. The final one of which is determine if alternate resolution to a trial on the charges should be pursued. So they do their work, and they can make several determinations. They can determine not to file charges, and in which case that's what they report and that's all they report. They can determine to file charges with an alternative resolution, or move to create an alternative resolution, or at least pursue the possibility of one. Or they can file charges and proceed to a trial. So those are the three. And there is a requirement in church discipline that alternative resolution can only occur along with a guilty plea. That's not to say that to what the person is willing to plead guilty can't be part of the mediation or alternate resolution process. But in the end, you cannot have an alternative resolution without the person pleading guilty to whatever is agreed upon to plea. If charges are not filed, the IC submits a report to that effect, and that concludes the matter unless within 30 days the person who made the allegation petitions for a review, another review. So they can't do it until the IC says, no, we're not filing charges. If charges are filed, again, the new rule is 1 year from the investigating committee's first meeting rather than 1 year from when it was formed. And the duties of the investigating committee at that point are to inform the accused of the charges and the summary of facts it expects to prove. And if charges are filed, now there is a requirement to state the specific provision of scripture and or the Constitution that have been violated, and file those charges with the clerk or of session or stated clerk. Session has one more opportunity to request reference. The stated clerk forwards to the PJC. So the point is, we put some extra wording in about charges. Charges must state what scripture or what provisions of the Constitution are being violated. And it was still, an offense was still the same name before. It was just not an absolute requirement that you had to name what it was. I have helped some investigating committees write charges, and I always make a strong suggestion that they do that. That is now constitutional language that they must. And frankly, they should do more than just list a provision of the Book of Order. They should start with Scripture and go through the confessions, and also name Book of Order provisions. And ordination constitutional questions are often among those. And then if they determine that they want alternative resolution, we did a lot of writing, a lot of praying and debating and hearing from advocacy groups in how to get this written well. So it is a greatly expanded section, and in the end, it describes 3 different forms of alternative resolution. One is restorative justice, about which none of us were experts, and we read a book on it, but determined that it bore weight enough to go in as an option, but without too much explicit language about how it would be done in our process. Although it's it's a page and a half of work on how it can be carried out. It's guided by 4 questions: who has been harmed, what needs do they have, who shares responsibility to address the needs, what's needed to restore wholeness to the community. And it sort of lays out how you could come up with a process that fit the definition. But we also left mediation as a possibility, and the possibility of some other kind of negotiated agreement. So we just tried to leave as much space as we could for investigating committees to do their work and come up with the best solution possible, which may be to go to trial, or it may not. But what's really important to know is that in any case, the end result is that whatever is agreed to, whatever kind of alternate resolution agreement exists, including the charges to which the accused pleads guilty and its rationale for adoption, go to the session or the PJC for adoption. So this then becomes ultimately the investigating committee convincing the PJC that it should be done. If agreement is not approved, it can be renegotiated. But if an agreement is not reached, the matter then proceeds to trial, because they have pled guilty and to certain charges, and so you go to the trial with that. Under the new rules, how is renunciation handled? When can renunciation be considered? Renunciation, that's early in the process where that is listed, but renunciation ends judicial process. That said, there are new provisions for how to carry out pastoral inquiries and take other steps, but renunciation ends judicial process. That may change because the General Assembly, at the same meeting where it approved church discipline, approved a process of being able to allow judicial process to continue after renunciation. But the assembly took that action with advice and knowledge that if church discipline is adopted, it will not go into the new book, because what was adopted in church discipline does not include that. So we'll see if that bubbles up again in a new overture moving forward. So question, does alternative resolution mean alternative to a trial? Yes, it does. Any of these would be largely for the purpose of not having a trial and not imposing a censure unless the censure is part of the resolution. It may include voluntary not participating in pastoral functions or other pieces as well. But yes, that's the point, is to not have a trial and resolve it in some other way than a trial and a determination and a censure. So for pre-trial procedures. The parties in a disciplinary trial are the prosecuting committee, and the way those are styled in how you write up the trial. It is the presbytery of such and such. Well, actually, that's wrong. It is the Presbyterian Church USA through the presbytery of blank, or the Presbyterian Church USA through the session of blank. It is the larger church which is being represented by the prosecuting committee on behalf of the whole church and through a particular council of the church, the session or a presbytery in almost every case, and the accused. Same language for circulation of materials and communication as in remedial. Unlike in remedial process, a pretrial conference is mandatory, and there are procedures spelled out for how that happens, including reading of the preamble. And there's a statement that says all actions taken at a pretrial conference are preliminary and shall be referred to the session or permanent judicial commission for approval at trial. So things that are agreed to there are only preliminary until they get affirmed later. We played a lot with deadlines, how long an attorney needs to prepare a defense, and how long a prosecuting committee needs to get ready to do its work, and when witness lists need to go out, and virtually all of those timelines were adjusted based on input from people who have participated in these processes. So if you have old papers that say you get 2 weeks to do this or 30 days to do that, the new rules have changed virtually all of those, including minimum and maximum deadlines for when a trial date can be set after the pretrial conference. Conduct of trial, same as in remedial. The moderator makes rulings, and those are subject to appeal. Additions, things that are different in disciplinary process, is there's a clear statement that the trial is to be held in a neutral place suitable to the occasion. So if you're dealing with the pastor of a church, you don't hold the trial in their church. You hold it in some neutral place that's suitable. There is a statement, because we're in individual discipline now, that the accused is presumed to be innocent unless a determination of guilt is rendered by 2/3 of the session or permanent judicial commission eligible to vote. And remember that back earlier on, we said, and there's a minimum quorum of 5, which means that at least 4 people make that determination. Again, wording that's from remedial for citations and testimony and how it works, and electronically received testimony and how trial procedures work. Except for these, there's a definite statement in disciplinary process. Someone wrote, Donna wrote CG30109B6 for options when someone renounces. So if you have more question about that, you can go back to G and look at it. There is a specific wording that says that the commission can close a proceeding. It's embedded in remedial anyway for the sake of order. You could remove parties, but this one makes it a little more explicit and easier because we're dealing with individuals and their alleged failings. And so it says, while they're ordinarily open, at the request of any party or on its own initiative, the session or PJC may determine at any stage of the proceedings by a vote of 2/3 of the members present to exclude persons other than the parties and their counsel. So, perhaps even if at some point in a trial you're dealing with very sensitive information or facts, you might want to close it while we deal with the next 2 witnesses and then come back or something like that. That's under the PJC's purview. So Catherine asked, would another church or the presbytery office be considered neutral? I would think so. I mean, you're just saying, you know, get out of the church where they have worked and where the people who feel harmed may be, that may be their place of worship, or at least their church facility. But yes, I think under normal circumstances, we're not saying you have to go to a hotel conference room or something, although that is often what the GAPJC did for its hearings, but we're talking about a disciplinary trial here. So yeah, another church or presbytery office if it had the room to handle it. Trial procedures, very similar. Objections of parties has slightly different wording, which we're going to look at in our final breakout session here in a minute. That is D80602, and you'll be referred back to the same section in remedial. And D80604 requires that the accused plead guilty or not guilty to each charge. That also happens in the pretrial, but they have to do that at the beginning of the trial. Everybody good on that? Okay, so as I just said, objection of parties has slightly different wording in disciplinary than it does in remedial. Specifically, it was changed in remedial from what was in rules of discipline. What's in church discipline is very similar, if not identical, to what was in rules of discipline. So I want you to look, the final document you received, document 4, lists those two provisions so that you can see clearly where the differences are. So in your final breakout group, I just want you to discuss what difference do you see in small groups, what difference do you see between the two provisions, and why do you think they were written this way? If you were a PJC moderator and such an objection was made in either one, how would you proceed? Those are the questions. And as we've done, make sure you know or introduce yourselves to the others in the room, and then answer those questions in 10 minutes. Andy? Okay. Welcome back. I'll just give you an opportunity to briefly say in the chat why you think those differences exist. Do you think they should exist? Wasn't as difficult as other way. Yeah, well, this one wasn't as tough, but I think the point of it is to get you thinking about when you need, as a PJC member, to consider recusing yourself. And the answer is not very often, really. But that specific wording of personally interested in a disciplinary case or materially interested in a remedial case is an intentional distinction between the two kinds of cases. And to the second, oh, let's see what's being said here. Personally interested, yeah. And I'll tell you that these sometimes get questioned. You know, I ask you to think about how you would proceed. People are not, they're only automatically excluded for a few specific reasons, right? So these are ambiguous enough that they have to be decided by the person, whether they want to do it or not, but ultimately by the PJC, whether to recuse them. And so PJCs, when that happens, huddle up and follow Robert's rules and discuss it and take a vote. And sometimes the decision not to recuse someone becomes something that gets appealed, because if one of the council said that person has personal interest in this and should be recused if they don't do it, then that can meet one of the standards for a reason for an appeal. So you just need to be aware of that. In both remedial and disciplinary matters, there are recusals. We had commissioners recuse themselves in one case because it was an attorney, and the counsel for one of the parties was a law partner of his, and so he recused himself from the case. I'm not sure he had to. By secular law rules he may have had to, but by our rules I don't believe he did. We're a church, and we're a small enough family that you just can't. We also had on GAPJC, people often say, ask the body, should I recuse myself? I served in the same church with this person when we were in our 30s, or whatever. And the general answer of GAPJC and its discussions about that was, we're a church family, and we're not that huge a church family. There are going to be connections. The question is, do you have a material interest or a personal interest? That is, can you be objective and fair about this or not? And if you can, and there's not a material interest, you're not going to make money off how this comes out, or you're not going to lose your pastor, or one of those things that is truly a material interest, then generally you at least may stay, but you can recuse yourself if you need to. But understand that affects quorum, and we have to have a quorum, and that's going to maybe require former members coming back on and serving in your stead. So be aware of that. Okay. Like, I would look at, okay. So feel free to read through the rest of the comments that are there. Evidence, largely it's what's in remedial, but it includes some explicit wording about what laying a foundation means. It says that why, let's D80701. Evidence must be relevant to be received and may include evidence that lays a foundation for the admissibility of other evidence. Relevant evidence is evidence that tends to prove or disprove a fact necessary to determine the outcome of a case. Laying a foundation means presenting preliminary evidence to show the authenticity and relevance of the evidence produced. Evidence of authenticity goes to show the item is what the proponent claims it is. No distinction should be made between direct and circumstantial evidence. That was something that was added after on the advice of the Advisory Committee on the Constitution. And I have a feeling that it really should have been added to both. I think it applies equally to remedial. I don't think you're doing something different in remedial. I think it just only got added in that section. So that's one of the things I've highlighted for further consideration as we find we have some cleanup to do on aisles 6 and 12 and such to get this finally done. So just so you know, that exists as a difference between the two, but I don't think it represents a real difference. One difference is hearsay evidence is explicitly noted. We've always allowed hearsay evidence, but we never talked about it. And a lot of attorneys don't like the fact that we allow hearsay evidence and question why we do. And so we felt it was necessary, if we're going to continue to allow it, to say why. And by the way, in the remedial section, we tried to ban hearsay evidence in remedial, and were convinced in the end to say should instead of shall. That is, witnesses in remedial cases should have firsthand knowledge, is what remedial says. 80703 on hearsay says, 80703. Hearsay is a statement made outside the presence of the session or permanent judicial commission hearing the case, whether written or oral, and which is offered to prove the truth of whatever it asserts. And here's the rationale. Because of the limitations of a counsel's authority to compel witnesses to testify in the disciplinary process, as well as the limitations of resources in investigations, hearsay evidence is allowed. The session or permanent judicial commission shall determine the credibility or weight of hearsay evidence. So basically, and this is kind of following what Robert's rule says, which allows hearsay evidence in trials, in membership associations. We're not bound by those. Our rules take precedent over those, but that's kind of what Robert's rule says is, in a criminal process or in secular courts, you can literally compel people to be there. They have to pay a fine or go to jail if they don't show up. We don't have that in the church. And as we talked about with citations, we don't even do second citations anymore. If somebody says, I'm not going, they're not going to go. And so then you have no case at all to present, or you have to rely on hearsay and determine how much weight you want to give it. So that's the reality we live in, and that's the rationale for why we are where we are. There are several provisions specifically listed under witness. One is that testimony from individuals appointed to provide counseling services within its jurisdiction, or not compelling spouses to testify, and also granting PJCs to recognize other privileges if they choose, like therapist patient, pastor penitent, etc. So PJCs have some leeway in determining whether they're going to allow certain people to be compelled to testify. And of course, they can only be compelled in the first place if they're PCUSA, and ultimately you can't really compel them. You just have to put them on notice that they could be disciplined through their own disciplinary processes in their entities. And then final statements, similar to remedial, with the prosecuting committee having the right to open and close the arguments. And then there's a decision rendered. In disciplinary trial, decisions must be reached while in session and announced in open session. A finding of guilt requires two-thirds vote of those eligible to vote on the judgment. So in remedial, you can do that, go away and come back in 10 days with your final. In disciplinary cases, you cannot do that. You have to stay and bring your verdict out in open session. Announce that you're ready, bring the parties in, announce it. So then you are required to have a hearing on the censure to be imposed. So if found guilty of one or more charges, or after a guilty plea that avoids a trial, that's if someone pleads guilty, you skip to hear, and you don't do the trial, but you still have to have the hearing scheduled as to the extent of injury suffered, mitigation, rehabilitation, and redemption. Victim impact statements are allowed and are not subject to cross-examination. So there's a victim impact part of that. And then sessions or PJCs meet privately to determine the censure, which is then pronounced back in open session again. So the way disciplinary matters come to an end is this process of meetings, series of meetings, based on the need to have a censure part engaged in it. The end of the trial section has similar wording to remedial, about filings and notifications and what if there's new evidence and records of proceedings. And then the trial section ends with the session or presbytery proceeds to enforce the censure regardless of an appeal. So appeal does not stay an action. Actually, if you read the end of that section, though, it says, unless there has been a full or partial stay of enforcement. I'm not exactly sure what that statement means, because there are not stays of enforcement in the disciplinary process. And I've personally don't recall when that was written or put in or discussing it in the committee. The only kind of stay of enforcement that could be in place was some sort of remedial case filed with a stay of enforcement based on something from the disciplinary case. I suppose theoretically that could happen, but we have AIs that say you can't attack a disciplinary decision with a remedial action. So how that would get filed and would proceed, I'm not sure. But I suppose in theory, it could be the case that some sort of stay of enforcement went into place. But the point is, under any other normal kinds of circumstances, appealing a guilty verdict and a censure that's imposed does not preclude moving forward with the censure while the appeal is in process. Okay, chapter 9. This one does not exist in remedial, obviously. These are the degrees of censure. There are 4 of them: rebuke, rebuke with supervised rehabilitation, temporary exclusion from exercise of ordered ministry or membership, and removal, as in permanent removal from ordered ministry or membership. I say permanent because there's still the possibility of restoration later. So for those of you familiar with rules of discipline, there's a new provision added in church discipline regarding it. It's a new statement that's in all censures. If you look into that section, you'll see, like, for 90103 is rebuke, and then for rebuke with supervised rehabilitation, it's at 90104D, where this is listed, and the censures are similar until you get to the part specifically related to that form of censure. But rebuke is the simplest one. And what we added was language that says that this is given without malice or vindictiveness. One of the original reasons that Chicago Presbytery sent the overture to have rules of discipline revised was an experience on the floor of Presbytery of carrying out a censure that nobody walked away feeling good about. And so they wanted the wording to be more putting the censure in the context of what we believe we're doing in discipline, which is that we're trying to build up the body, not tear it down, build up persons, not tear them down, but still do what we need to do for the sake of the community. So that language is added. And also we added explicitly that it may include a summary rather than the entire content of the session when it is being reported out. So the full censure is received there, but when it's reported back to presbyteries or congregations and places where it now has to be reported, you don't have to read the entire document that the PJC puts out. You can read a summary of it, which presumably the clerk or stated clerk puts together what they consider a summary. And so we added some rules about where and when those reports have to take place. Number one, it was experienced that when church members were censured, the congregation never knew about it, and it never was recorded anywhere outside of the session, where minutes are the possession of the session members, not the full membership, if they choose not to. So there is now a provision that says when a session censures a member, they must call, or when a presbytery censures a commissioned pastor, it has to be reported out from there. And it's actually a change in G. It's added as a new purpose for congregational meetings. So that's G1. So G10504G says receiving disciplinary decision against a member of the congregation as required by D90102 is now a proper purpose for a congregational meeting. And also reporting of commission pastors back to their sessions if they are disciplined as commission pastors by the presbytery rather than by their council of membership, so that their council of membership is aware that they have been so censored. Generally, the place where the church was having the biggest problem with censures was in temporary exclusion cases. The rules for temporary exclusion used to say that it can be for a specified period of time. But the rules also said that at the end of that specified period of time, the council has to vote to receive you back into active membership from the exclusion. So we tell someone they're excluded for 2 years. At the end of 2 years, they come back and ask to be restored. The council may still vote against it, and you can't compel a council to vote a certain way. So the best solution we came up with was to say that instead of a specific time, it could be a minimum time, a maximum time, or both, during which you are required to complete certain actions. That was optional in exclusion, temporary exclusion before. You didn't have to have a rehabilitation process along with it. Now that process is mandatory. There can be a timeline. At the end of that timeline, the person can apply, and the council has the option of either receiving them or extending the time or making the exclusion permanent. I'll let that sink in for a minute. It is a significant change. And we worked hard on this one and thought and prayed a lot about whether we wanted that. One of the realities we found is that in that process of dealing with cases, maybe even from an alternative resolution where a person agrees to be temporarily excluded for a period of time, which can happen as part of that. That's a negotiation process that happens between the person accused and the investigating committee and the permanent judicial commission. But the body that has to make the restoration decision is the full council. And sometimes they are not where the PJC was when it accepted the agreement. And so we believed ultimately that it is unjust to keep someone in this limbo of being temporarily excluded forever if their council is never going to vote otherwise. And that the best way to proceed would be to allow them to make it permanent. That said, I think we were that. Yeah. As has always been the case in our polity, a process exists even for those permanently removed from office or membership to seek and be granted restoration. So even if they make it permanent, which ends that judicial process, that doesn't mean that at some point in the future, they can't start over again and seek to be restored. Okay, let's see what questions we have. Apologize, I may have missed some here. With the potential to lose PJC members for conflicts and quorum being 5, should a PJC membership start with more than the minimum of 7? What number do you recommend? I recommend 9 as a minimum, because then you're always there. A minimum of, you won't get below 5 in all likelihood. But that's why we wrote the provision that some presbyteries may not have 9 people in them, including the rotation time off, to be able to do this work well. So I think it's more important to get people who can do the work well than to have a certain number. So that's why we chose to leave it at 7, but require a quorum of 5, which always allows you to go back and get former members to make it up. And where is the rebuke publicly pronounced? So it is what the censure is announced at the end of the hearing that follows the trial, but then it is pronounced in the council of membership. So for a session that censures a member, they pronounce it at a session meeting. And for a presbytery that censures a minister or a commission pastor, it is at the presbytery meeting, at a presbytery meeting. And then there are additional notice requirements, like the new one that a session then calls a congregational meeting and makes an announcement of it. It's pronounced before the session to the person, but they then announce it to the congregation so that it's in the congregation's minutes. Okay. And disciplinary appeals, and it is 2:03. Let's take a break for 10 minutes. Thank you. Before I go on to appeals, I want to go back to the last question I see in the chat, which is about the announcement that a censure is terminated. I want to make sure we're clear on how censures are terminated. So if you look at D90105H, it says a person under the censure of temporary exclusion shall apply in writing to the council through the clerk of session or stated clerk for restoration upon the completion of the supervised rehabilitation pronounced. The council that imposed the censure may approve. So they apply, and the council then has it on its agenda. The censure may approve the restoration when the council is fully satisfied that the supervised rehabilitation pronounced has been successfully completed. The censure may include a time limit for the completion of all terms, after which, if the terms have not been met, the council may, at its discretion, grant an extension for a specified time or make the temporary exclusion permanent. Early restoration, a person under the censure of temporary exclusion from the exercise of ordered ministry or from membership may apply in writing to the council that imposed the censure through its clerk to be restored prior to any minimum period of time included in the censure. The council may approve such a restoration when it is fully satisfied that the action is justified. So it doesn't just happen. It has to happen by action of the council that at the presbytery level through its commission on judicial commission imposed the censure. But it's the council itself that has to vote to end it. Okay, everybody clear on that? And the same for restoration. G90201, a person under the censure of removal from ordered ministry or from membership may be restored by the council imposing the censure when the council is fully satisfied the action is justified. The person makes a reaffirmation of faith for restoration of membership and or is again ordained for restoration to ordered ministry. And I don't believe, with the exception of the part about extending or making permanent, that's the way we've always done it. Okay. Now, I have just a few slides, so we're actually now ahead of time. And if you have other questions when we finish, I'd be glad to take them. But let's finish up the appeal chapter, which is very simple because it's almost identical all the way through to remedial. Here are some exceptions. Number one, there's in remedial cases, either side, whichever side loses, can appeal. There was a brief period of time in our denomination's life when that was also true in disciplinary, but it was only for a meeting cycle or two And then we went back to saying, no, only the person found guilty may initiate the first level of appeal. So if a person is found guilty, they may appeal that and attempt to have it reversed. After that, so for the second level of appeal, which would be no lower body than the synod, either party can initiate the next level. The grounds for appeal are the same, with one addition, which is undue severity of censure is one additional reason for an appeal. There's added wording under the duty of the stated clerk that a notice of appeal, if properly and timely filed, shall suspend further proceedings by lower councils until the appeal is finally decided, except that any censure may be enforced. So it's another wording of you keep going on the censure. And unlike remedial appeals, an appellee brief cannot raise additional issues related to the decision being appealed, and therefore there's no provision for filing a supplemental brief. That's all remedial stuff that does not apply to disciplinary. The pre-hearing conference provision does not include the possibility of a settlement agreement as in remedial. Again, that's not about a disciplinary process. This is, so that's not what a pre-hearing is, a pre-trial hearing is for. And finally, the chapter on disciplinary appeals ends with this. If the permanent judicial commission reverses all determinations of guilt, it becomes an acquittal, and the person is automatically restored to ordered ministry or membership in the church. This declaration shall be made in the lower council and recorded in the minutes of the lower council with jurisdiction over the person found guilty. And with that, I am through all 100 of my slides, and I will stop sharing and let you all back, and now entertain any other questions. Anybody raise a hand if you want to ask anything else? Or, okay, Andy?
I have a question regarding, so the interaction of old and new. If someone was found guilty and placed under censure under the previous rules of discipline, do those provisions still continue in effect, or do these new provisions related to censure and restoration apply to that person? Or do we have any sense of, is that going to be something that we have to litigate to get an answer on? Or is that going to be one of the things we get sorted out through an AI?
Yeah. One of those. And it may be something that needs to be asked so that the next GA can consider an AI on it, so we don't have to wait for a court case to get filed about it, which takes a lot longer to get through the system. That might be a very good idea, but the Rules of Discipline Task Force made no recommendation on that question. Teresa.
I just wanted to be clear about the investigating committee. 70501 says when a clerk of session or stated clerk receives an allegation, and then it says without undertaking further inquiry. And I was thinking that you said that it was the stated clerk who determined if it was timely filed and the other levels of the allegations. I just wanted you to be,
in terms of what's in a checklist, I mean, it becomes
Yeah.
a bit of a gray area. They're not allowed to investigate and tell them it can't happen. But you know, in my work as a stated clerk, I like to let people know where they stand and say, I'm forwarding this through, but just so you know, these are our rules, because very often when that begins to happen, they haven't dealt with them. So
I usually go over that in the training with the IC, you know, here are the things you have to do. and here's what I already know. Here's when it came in. Yeah. Okay. I just needed clarification. Thank you.
Yeah, thank you. Valerie, if there's nothing, oh, there's something in the chat. Yes, very much. The person to call would be Flor Velez Diaz at Office of the General Assembly and Constitutional Services. She's the Judicial Process Manager. And that is what she does, is assist people with that sort of thing. In fact, she'll come and do trainings of ICs or PJCs or whatever is needed as well. Yeah. Donna.
I have a little bit of confusion still with the summary regarding to the council about a censure, and yet, for example, under the censor pronouncement under temporary exclusion, which is 90105J, blah blah blah, and it says declare you're temporarily excluded from blank a period of time, and until completion of the following rehabilitation program supervised by as described below. So that makes it sound like you have to write the entire rehabilitation program or pronounce the entire rehabilitation program. Is that correct?
Yes, that is correct.
So it's only the charges that you can summarize? Or
yeah, so in past history, it has been believed that the entire order that the PJC puts out has to be read in its entirety to the council. That's what can be summarized.
Okay.
It can include, you know, the nature of the offense, but it doesn't have to give every allegation of what was done when, by whom, and all of that's what can be summarized.
Okay, that's helpful. Thank you.
Yeah. Anything else? It's been great to be with you. Valerie, I'll turn it over to you to take us out.
To say goodbye. Thank you all so very much. Thank you, Greg. Thank you, thank you, thank you. We will, and thanks also to Andy James for all of his work behind the scenes.